We know that in our professional code of ethics, very important, that palliative care is actually provided in all care settings, and we don't even think about it all the time. So it's consistent, with existing ethics conflicts that are there, standards of care, relevant for everybody. But clinicians, and all of us are clinicians versus the providers, aim to prevent, identify, and really problem solve all those ethical things. Everything from choosing things to choosing to discontinue non-beneficial things. We look at the do not resuscitate or allow natural death orders, use of sedation. There are many, many examples that are going to be out there today.
So when autonomy is important and for a individual to make their own medical decisions. So the autonomy is the principle of respect, usually associated with allowing or enabling patients to make their own decisions about which healthcare interventions they will or will not receive. One of the most important federal constitution decisions was a U.S. Supreme Court case, Cruzan versus the director of the Missouri Department of Health. The case involved a young woman named Nancy who had been severely injured in an automobile accident. Her health had deteriorated into a persistent vegetative state, meaning that she had no higher brain functions, and she was kept alive only through an array of aggressive medical treatments and procedures, including artificial hydration and nutrition. And the case was brought about when her parents, 5 years after her accident, sought a court order requesting that all artificial means of life support be terminated. And the state of Missouri intervened in that case, contending that there was no constitutionally protected right to die. From that case, Congress enacted the Patient Self-Determination Act, which I will discuss more as we go.
Another very big one is beneficence, to do, good for everybody. So this ethical, principle that all us as healthcare professionals treat patients in a way that provides maximum benefit to them. It may not be what we would think would be that way, but it's always to do good. Then the one that we also want to do, though, is do no harm, So our obligation is that whole balancing act. And sometimes we feel that we are intentionally inflicting harm when we don't want to. And so, when people say keep doing things that may not be of benefit. So it's very important to know non-beneficial care and treatment. So this is treatment that's determined to be based on current medical knowledge and experience, holds no reasonable promise of contributing to the patient's well-being, of achieving goals of care. So these are things that, may work for one person, may not work for another person. Just because it's there does not mean it's going to be a benefit for somebody. And so they use the word care, but I'm going to stress it's treatment because we can always provide care. Very, very important for that. The doctrine of the double effect then is that distinction between we're trying to do something that's there, that we're trying, that the action itself must be not wrong. It's in the effort of the good for the patient, the beneficence we just talked about, and it should not bring a bad effect. It may sometimes do that, so it's always the balance between the two, but the good effect must outweigh the bad to make sure that we move forward if there's a potential for a double effect from there.
And as we go through what the ethical considerations are and what you are legally required per North Dakota Century Code, I would touch on that there are duties of provider as set forth in Code 23-6.5-9. And that really provides that principals, healthcare or long-term care services provider and employees have knowledge of the principal's healthcare directive. So that the patient has the right to decline treatment and to cease any artificial hydration or nutrition. Also foregoing or stopping any ventilation, dialysis, other treatments that may be considered aggressive treatments or invasive. Also, what the patient feels. When I discuss with patients, or with my clients as we're preparing a healthcare directive, we often talk about medications that can be sedating, and North Dakota does not permit physician-assisted death.
Right. And the other thing too is sedation for imminently dying does not mean we're hastening the death. There's that fine line, just like we would do with people on ventilators, et cetera, where we're going to allow them the natural process of that. So, and as she said that the physician-assisted death is not allowed in our state, where there are quite a few states that are nowadays, aren't there, Kelly? There are more and more.
Yes.
So go ahead, this is the legal one for you again.
Okay. So some of the considerations that I discuss often with our clients is who they would want medical records and health information released to, which relatives, friends would a client want to have access to their doctors, and who is able to make medical decisions in the case that my client is unable to state or otherwise allow their healthcare provider to know what their decision would be. We also talk about some advanced care planning, what their wishes are regarding nursing care or remaining in their home, and the roles and responsibilities of the agents who they appoint to make their medical decisions in the event that they're unable to. Another thing that has come up quite a bit recently due to COVID is when a person does not have a medical directive or any power of attorney in place and is hospitalized and cannot make medical decisions, there is a guardianship proceeding to have somebody else appointed as their medical decision maker, as well as legal and financial. Another concern that often comes up is whether or not whether appointed agent or another person in a client's life is abusing or neglecting an adult who is in need or in that may be taken advantage of. And I'll let Nancy finish with some of the hospice care and controlled substances.
Yeah, a lot of times when we're thinking hospice care, we think of elders, but we even have the pediatric side of it. And that there are legal ramifications there because they are of minors, that we have to work with the family member that is directly involved, and that there aren't any, ramifications there. Definitely, we know in our role with prescribed controlled substances that we are doing it, appropriately within the legal ramifications versus just writing it as a medical order. The pronouncement of death and death certification also falls into the legal ramifications of what we do from a perspective of palliative care and hospice. Autopsy requests, organ and anatomical donations also become not only medical side, but the legal considerations that are there. And then we see all these emerging issues such as medical marijuana, the physician aid in dieting that is really being talked about, and definitely opioid abuse that we're seeing everywhere.
So substituted judgment is in reference to the ethical duties of an appointed guardian or a nominated agent to make medical decisions on behalf of a client or patient. It's very important that that person who is in that role understands the patient's beliefs and values prior to making any decisions on the patient's behalf. Often while not legally required, clients ask that whoever their nominated agent is, that they visit with other family members, whether it's children, a spouse, and really have a good grasp of what that patient's beliefs are before making, and that everybody can come to some agreement on how to move forward with a medical decision. So as for legal guidelines, North Dakota Century Code does provide which persons are able to give informed consent for an incapacitated patient. So we also, if somebody does not have a healthcare directive or medical power of attorney, then what is required is to have a guardian appointed to give consent if the patient is over the age of 18. And there are going to be more and more regulations within the medical providers and what who they go to for making those decisions and following the guardianship proceedings to have someone appointed by the court.
Do you want me to show that? Do you want me to click on it and show the actual guidelines, or we'll let other people do it?
We'll let them, they'll have an access to download the slides, right?
Yep.
Okay. So just some of the combined legal and ethical issues that come up would be whether or not there was a request from a patient or family that is not medically indicated or could cause undue burdens on the patient. Were you going to cover some of the, I'm sorry, I don't have our notes.
Yeah, a lot of these are cross-referenced, but we wanted to show that it's not only legal, now we have an ethical issue that goes along with it. We've talked about several of these already, the technology component, cessation of medical oral nutrition and hydration versus if we do tubes and other things, the artificial side of it as well. We already mentioned about sedation, the aid in dying, and determination of capacity. That's another one that really is both legal and ethical, because we can get into a very heated conversation that goes along with that. And what about children in foster care and protective custody? You know,
so if there's a child in foster care or protective custody, generally it's the social services agency who will have a court order, and that will authorize the agency to make medical decisions for that child who does not have a parent who is capable of making those medical decisions for them. So often, if you know that a child is in either foster care or some kind of social services custody, I would always recommend that you request the court order and look to that order. And that's who would sign any medical authorizations on behalf of that child. I would also touch on considerations for patients who don't have caregivers in the home or other availability for support to help them to whether it's transportation to and from medical appointments, or some kind of service, or family member who's able to deliver medications, check in on a patient, and make sure that them continuing to live independently is still in their best interests. And then I would also touch on any patients who are incarcerated in custody of a law enforcement agency on parole or have other legal issues impacting their care, and how those if they like how certain medications if they are prescribed them, that information may need to be provided to the court or to a parole officer, just to make sure that if there is any kind of testing or anything else that they're not violating a court order if they test positive for any substances. Also, whether or not any if there's any need for a mental health evaluation for anybody who is in legal trouble.
So we as medical professions, we are obligated, of course, with the diagnosis, to have some kind of being able to disclose that, looking at decisional authority, with who is the person, we have to have the, like she said, by century code, the laws of it's not just necessarily who they put in case of emergency or next of kin, et cetera. There's more to that. And then also when we get to the point of accepting of or decisions to forego treatments, whether or not they're beneficial or non-beneficial, person's capacity to make those kind of decisions. So it's our obligations to be able to go through this as a duty of care.
So there are a number of different kinds of advanced care planning documents. There's also various different titles for these documents. And even for myself, that can cause confusion, but I try my best to inform our clients so that they are able to advocate for themselves while meeting with medical professionals and share with their healthcare providers what their preferences are regarding treatment, especially in the event if they're no longer able to speak for themselves.
And we really did look through, what these kind of documents are. And there are differences between a legal document and a medical order. And that gets confused a lot of times where people think like the DNR and the PULSE needs to have legal ramifications, but it's the same as a procedural, or when we're doing the different kinds of surgical consents, where the risks, the benefits, expected outcomes, all of that is discussed as a medical order. The legal documents, as Kelly just said, are the things like the financial side of it, financial power, and as well as like the living will, healthcare directive, HIPAA release, all of those things become the legal components of it.
Yes, I often have clients who, if I ask if they have a medical directive, healthcare directive, they'll say, I have a power of attorney. And often the power of attorney is only for legal and financial decision-making. And so it's just education of our clients, what is authorized in each of the legal documents.
And we wanted you to know that we have many previous Project Echoes related to advanced care planning. We are truly getting into the legal ethical side today, with some of our case studies, et cetera, that we're going to be presenting. So these are all available for you. We're trying this, otherwise we could make this, 2-3 hours long, right, Kelly?
Yes. All right, so North Dakota Century Code, this is the statute which guides what is a North Dakota Healthcare Directive. The statute also provides a form which is available for anyone to download and print and sign at no cost. So if you can advance to the next slide, I think I have. Oh.
Nope, that's
it might be coming up. Yes.
You come back. But
okay.
We at Honoring Choices also have a long form of part, but by law, and Kelly will agree, you can take any piece of paper right? It doesn't have to be a form.
Yes.
Whatever your thing's on, and by law, it's the who notary, to says who's your signature is, the notary, the two-person, whatever. And Kelly's going to get into more of that. But I wanted to introduce you, if you're not familiar with our Honoring Choices North Dakota, again, we have a Project ECHO on this, but we also have included things like the forms, the conversations, all of that, so that we can meet the legal and ethical sides of what we need to for these conversations that need to occur.
So what is an advance directive? So an advance directive can be any of the documents that you see over on the right side of your screen. Often they are legal documents. Nancy mentioned that there are also medical orders, which are different from the legal and have different effects than the legal documents. But an advance directive is a legal document that allows patients to put their healthcare wishes down in writing, or appoint someone they trust to make medical decisions for them if they're unable to communicate what their wishes are. So often when I meet with clients, we prepare a healthcare power of attorney, which names a primary agent to make medical decisions for them. And then if in the event that that person is unavailable or not willing to act in that agent role, then often we have one or two backup choices for healthcare agents. The living will is a document that we, as an attorney, we work with our clients to review and sign if that's what the client's wishes are. A living will in my firm is a document that says that if there was in the event that there is no possibility of a patient living a fulfilling and meaningful life, meaning that they're in like a persistent vegetative state, or they have a terminal illness and are getting closer to dying, that they would like to have any life prolonging procedures withdrawn. And so that is a document that I often review and offer to each of our clients, and it's up to them if they want to sign that. That takes the burden of that decision. My clients always say about unplugging me, but that is really removing that burden of that decision to withdraw life prolonging procedures off of the agent's shoulders. So it's a writing that the patient has signed, and it explains that if there's no chance of recovery, that they do not want to continue to live in a vegetative state. A do not resuscitate order is a medical order. Although our living will includes language regarding DNRs, it's my understanding that in order to be effective needs to be reviewed with the healthcare agent or the patient and signed by a medical professional. And then we also, while doing estate planning with our clients, sometimes, not always, but we have some clients who have decided that they want to donate whether their whole body or certain organs for transplantation purposes, or science or research, or I even have a few clients who have registered to donate their full body to the medical school in Grand Forks. All right, so the purpose of this slide is really to explain again what the difference is between some of the legal documents that we prepare. So a healthcare directive, also called an advance directive, My office titles it a medical power of attorney, but that is a written document that's used to express the preferences regarding medical decision-making. So appointing someone to make decisions in the event that a patient is unable to communicate. And then the document often also provides a number of other key decisions, whether or not the person wishes to continue to live in their home as long as that is feasible, what kind of treatment that they wish to have provided, if there would be any treatments that they do not want, absolutely do not want to have provided to them. Sometimes we have clients who have substance use disorders, and they have requested that they don't want to have pain medications administered. So that would be something that you would find in the healthcare directive, advanced directive, medical power of attorney. It doesn't always nominate a healthcare agent, but most of them will. A living will is the statement like whether or not somebody would want to have life prolonging procedures continued or withdrawn in the event of terminal illness, or if there was no chance of recovery. And then a will or a living trust is more financial and legal document. And that's really regarding the distribution of financial assets for in the event of death. A living trust is generally it's a document prepared so that if somebody is incapacitated or no longer able to make their own legal and financial decisions, it appoints a trustee in place of that person to manage legal decisions, signing contracts for the individual, managing their bank accounts, being able to sign deeds on their behalf. So a will or a living trust is not ever anything that would be presented in a medical setting. That would be a living will. So I'm sure you can see how there's some confusion for a lot of our clients as to what a document is titled and how it has effect.
And it makes even more confusion if you look in the world from state to state, even, the different names for that advanced directive. In North Dakota, we call it a healthcare directive. Some people, like she said, would call it a living will, personal directive, medical directive, advanced decisions, mental health advanced directive. I mean, there are many different names to add to the confusion. And
yes.
Then the healthcare agents themselves. Healthcare proxy or agent, medical power of attorney, healthcare power of attorney, healthcare attorney in fact, healthcare representative, surrogate decision maker, guardian, conservative. So it gets more and more confusing. So this clarification, that's part of the ethical and legal ramifications of what we need to do and conversations on what is it we're really trying to obtain in the long run. So we had so much fun. Kelly and I were like, oh my gosh, look at all these names, to throw in the confuse people even more.
Yeah, and I'm sure we haven't even touched, I'm sure there are many more that come up.
I went to the American Bar Association, so I tried to look there. I went to almost every state to try to find it, with what it is. It's just very, very confusing and doesn't help us at all. In North Dakota, we have the as she said, the statutory form, but you can use any piece of paper by law, right? It's the saying that who that person is, that verifying that they are signing it. We are not in our state you can't use like a video, we found out. It has to be in writing. And so we do have what we call our short form on our Honoring Choices site, which is very applicable. So a one-page document with one page of instructions for ages 18 to 40 that are healthy. And then we have the more long form for the more comprehensive one to give people ideas, for that. We also are, there's a Catholic Health North Dakota healthcare directive, and we are working towards getting, there's a tribal advanced directive coming very soon. We're very, very excited about it. That's going to be national, and it's coming through NEJI, and we're excited, and we'll include that probably on our website as well. So there are many examples. There's 5 wishes. There's a My Directive app. It can go on and on and on. But these are ones that are most applicable within North Dakota that we're using from there.
So the statutory form that Nancy had mentioned is it's a healthcare directive that is provided by our legislature has approved and is part of our law. It can be used. It's an optional form. It's not required. We, as attorneys or patients, are not required to use that language, but it is something that is available to everyone at no cost. And there's another form reference there as well. And as Nancy had mentioned, that they also have on their website other forms available. I have had clients come in with the 5 wishes. We have some clients who have specifically requested the Catholic healthcare directive. So I try to work with our clients, whether it's a specific form, or we sometimes work and make sure that their directive is states what their wishes are. I always let our clients know as well that they can change their mind. If they have executed a healthcare directive and they have changed their mind, then we can have them sign a new one, and that will replace and make the old one no longer effective.
Kelly, do you run into people bringing in documents from a health system? I find that different health systems have their own healthcare directives too. So they're
almost every time that we get to this part of meeting with a client, I'll ask them, does your doctor or nurse ask you at each appointment if you have a healthcare directive? And they say, yes. And they gave me this booklet and it was too much and I couldn't get it filled out. So I say, well, we can use that, or I don't charge extra because I think it's so important to have a healthcare directive. So we just do a flat fee and we include and offer all of our medical power of attorney forms and other healthcare related decision-making documents to all of our clients. But yes, that is, and then I always tell them, now you can tell your nurse or your doctor that you have taken care of that. And I often tell them to bring in a copy of, and to provide that to their primary doctor so that it can be kept on file and referred to if there was ever an emergency. All right, so this is that statutory healthcare directive that is available for free. And I didn't include the full document, but this is just the introduction at the top of the first page. And so a patient or client would just write in their name, and the document will allow them 3 different options. They don't have to do all of them. They can just do 1 or 2, but the first part is naming another person, the healthcare agent, to make healthcare decisions if the individual who's signing this is unable to make and communicate their decisions for themselves. That the agent must make decisions based on the instructions as provided in the next part. And any wishes that have been explained to that agent, whether verbally or in writing. And also that the agent who is nominated must act in the best interest of the patient if that person has not made their healthcare wishes known. Part 2 is of this statutory form gives instructions specific to guide the healthcare agent or medical providers in making decisions. if there is a named healthcare agent, then those instructions are to be followed by that agent. And then the part 3 allows the person who is signing to decide whether or not they wish to make an organ and tissue or tissue donation upon death by signing a document of anatomical gift. So all 3 of these can be completed. In my experience, when I am working with clients, I went away from using this form because they would often sign it and then not complete any instructions under part 2 and or 3. And I know that that's an option, but it was more that they thought, well, I'll just get around to doing that later, and then never would complete it. So I make sure that we sit and discuss. It's often not a very comfortable conversation, but we talk about what their wishes are so that we can include that in their document for them rather than making them fill out this form.
And that's what makes it legal and stuff too, which, you know, that's the important part. But
yes,
you can have those blanks in there, and people do, you know, they, you know, by default, if we don't see anything, you know, it's there. So what we have now is we have what's called a pulse, and Kelly wants to be giving pulse out. I said, no, this is the medical side. This isn't the legal side, but it's truly that process. You know, it's part of that advanced care planning, recognized nationally, state programs have it, but it becomes a medical order completion, like I talked about. It helps to translate what people want today into a medical order. And it's only used for those people, you know, that are seriously ill, having chronic disease, et cetera, with that. So that it's not for everyone, but it's truly with that conversation when people are nearing the end of life with risks, benefits, burdens, expected outcomes, what their preferences are, and travels with them across various settings, which we really, really like. There's state-specific names to it. So now we're just calling it, ours was still the physician order for licensed name treatment, but it's called PULSE. Everybody knows it as PULSE nationally. We've had many previous ones about this, but this is a great way to translate the legal document or what a person's wishes are into what do they want now. They complement each other, but it is the medical order side, not the legal side. And we Kelly and I talked about this. No, you know how important it is with that. But our essential things that, you know, we're hoping that you understand is that we need medical ethics education going on, so we understand these principles and focus on people with serious illness and end of life, for people palliative related and those that are more hospice. So learning about advanced care planning, I'm so glad that you're attending this, and look at some of the other ones. You know, what are some of the common scenarios that cause these legal and ethical? And we gave some examples of those. And then how to access the legal experts, you know, like Kelly and other people that help us to do that. Definitely ethics and ethicists and ethics committees are very, very important. And then to know how to reach the specialists in palliative care as needed as well, because everyone provides it. Everybody's a primary provider, but we want to do that. The ultimate goal, though, is to ensure that the provision of high quality care aligns with what the patient goals are. And we're all in agreement with that, both from a legal and an ethical. I have 3 quick, we're kind of watching our time here because Kelly's got some really great examples, but here was a practice example that we have for just in long-term care setting, you know, that we have a person with programs and the physician assistant and social worker wanted to improve advanced care planning and completion of forms. So, you know, the people that are different levels of decision-making capacity, and we're talking capacity versus competency there. So we need help on how to determine that capacity. So the team came in, they had ethics consult with that. Education was given on how to determine capacity, which we're not going to spend a lot of time with today, to help with those challenging scenarios. So, you know, working with the family, whoever's involved, you know, the decision maker, the healthcare agent, to move forward with that. In a rural practice program, we've got large things with that. So there's a lot of stress with ethical issues. We've had people actually asking for medical aid in dying, impaired decision-making, family conflicts, a lot of these things we've already talked about. So we've, you know, it's important to look at designing ethics forums for education, having project echoes. to be able to discuss some of the challenging cases that are there and identifying some of our practical measures for that support. So we want to be able to host online education and provide podcasts, whatever is needed for teams if necessary. So that's one other avenue that we could do. Dual visits with practitioners and social workers, fantastic, so that we can do that balancing act that's there at any given time. And then my last case, this is Ethel. I get made up some from ethical, that's why I made her Ethel. She is a 86-year-old lady living in a skilled nursing facility. She's got severe dementia. She no longer recognizes her family. She's dependent on others for all of her ADLs. She's being offered spoon feedings, but often turns her head away and tightly closes her mouth. The staff have only 15 minutes over mealtime to assist her. Family is insistent, I'm sure you guys have heard cases like this all the time, that Ethel be fed, but out of state and unable to assist herself. They're not there to do this. They're asking that she be force fed with a syringe feeding or put in a feeding tube to be inserted. So, what actions are we going to take? What steps should be involved? And what does Ethel want? What did she want previous? It always seems too early until it's too late. So having these conversations way, that's why we recommend, as early as 18 to start having these conversations. So, again, what steps or actions should be taken? Is it ethically appropriate to force syringe feed her or tube feeding if she's turning her head away? Is this her decision or she's a capacity thing? And who should be involved? Again, we could have, a 15-minute discussion on this. And if we have time, we'll come back to this case, but I want you to be thinking about this because this happens all the time. I can tell you, I have two hands in times that I've had similar situations in my practice with helping with people in long-term care. So we'll come back to Ethel in a minute here. So Kelly, you're back up.
Sorry, I'm here. I had to turn on, I had music playing in the background.
Oh, fun. Well, we can listen to music.
I think so. I'm just on so part of the reason that I was introduced to Nancy was because I had a lot of questions about what PULSE meant and what were the requirements. And what was the difference between a PULSE and a living will. But in preparing for today's presentation, I found a statistic that only 2 to 15% of our population even has a healthcare directive in place. And so I would continue to remind your patients, families of people that you are taking care of, that a healthcare directive is a very important document, sometimes more important than a will is, because if you don't have a will, the state of North Dakota has a plan for distribution. But if you don't have a healthcare directive and you don't have someone appointed to be your agent, it can be often very expensive to have a guardian appointed by the court. It takes several months to have that in effect. We often do an emergency guardianship and then have to follow up and have another hearing. And there's a lot of medical providers are involved. Another attorney is appointed to represent the alleged incapacitated individual. And so it can be upwards, I would say $5,000 to $10,000 to have a guardian appointed. But if you want to just advance to the next screen, I think, so I have provided a case study that kind of goes over how the medical and legal professions need to, we can work together to make sure that our patients or clients' wishes for care near the end of their life are documented and legally can be enforced. So if you want to go through the, I think the next slide. All right, I'm really working up to this, but just to go over like the practical approach of how this an aging couple, and most every attorney in North Dakota, especially in rural areas, is working and practicing elder law, meaning that we are advising our older clients regarding their health care. How are they going to afford long-term care if that's necessary, and what their plans are as they're no longer able to continue to live independently, especially those couples who are still living out on a farm and farmstead, far away from town and from their medical providers, and needing transportation assistance and even just general upkeep on their home. So if you want to advance. So in order to kind of go over how some of these legal issues come up, this is Ralph and Judy. And so I just wanted to present Ralph, at the suggestion of his doctor, consults with his attorney regarding an advanced care directive. So this scenario goes and just reviews some lost opportunities due to lack of clear communication. So Ralph and Judy met with their business attorney to update their will. And while they're in that meeting, Ralph mentions to his lawyer his recent medical diagnosis. And the attorney then says, well, we'll just do an advanced healthcare directive for you as well. Here are the forms for you to complete. And we'll just include this, we'll throw it in as part of your estate plan package. At that meeting, there's no discussion regarding Ralph's healthcare wishes, other than Ralph stating that because he doesn't want to burden Judy with difficult medical decisions, he'd like his oldest son, Jonathan, to be his agent, and then his daughter, Rachel, as an alternate agent. He also mentions to his lawyer that he wants the plug pulled if he no longer recognizes his family members. Judy tells the lawyer to name Ralph's surrogates to serve as hers as well. So Judy says, if that's who Ralph wants, put Jonathan as my first and Rachel as my second. And Ralph agrees. So, but Ralph is a private person. He's ashamed of his diagnosis, and he does not want to discuss his healthcare wishes with anyone other than him telling Judy to promise that she will never put him in a nursing home. Ralph does tell Jonathan and Rachel that he named them as his healthcare agents, and Ralph mails copies of the signed healthcare directives to his children to sign and return, but he doesn't tell them what his wishes are. He doesn't write it into the form, and he does not provide any copies to his medical provider. So there are a number of issues that come up legally and ethically in this scenario. So I would just like to touch on that one of the lost opportunities was that the attorney just said, I'll just throw in this extra form for you. They didn't stop to discuss what Ralph's diagnosis was, what his wishes were regarding what kind of treatment he wanted to be provided. He didn't even say anything about whether he wanted to continue to live in his home for as long as feasible, or what his wishes were regarding nursing home placement. So the attorney really failed there and didn't do a good job with addressing those issues with Ralph. And then I would also mention that when Judy, this often happens where we have one spouse when we're meeting with, and that spouse knows what they want and they say it, and then the other one just kind of goes along. So Judy didn't really explain what her wishes were. So that would be another issue I would just really present. And so it's always been in my practice, I want to have those uncomfortable conversations with both Ralph and Judy so that they can hear one another as to what their wishes are and their feelings regarding treatment. And then I encourage them to discuss that with their family members. So that I feel like if if a person explains to family members what their wishes are, that they're more likely to be followed in an emergency situation. Nobody really wants to go to the legal document and look at that, but generally there are memories of that conversation to help guide family members and to help children get along in that situation. The other thing being that so Judy Judy is not Ralph's healthcare agent. So even if he explains that to Judy, if something happens to her and she's no longer capable of communicating, then all of Ralph's wishes that were expressed verbally are now lost. So their children do not have that information. Were there any things that you would want to bring up with this, Nancy?
No, but I'm just thinking how nice it would be if we saw this documentation in the medical record under their advanced care goals of care planning. And if you knew more about, that we could share this information, but they're two separate entities, but there's so much legal, ethical, with that conversation, and the fact that even the healthcare agents aren't involved with part of the conversation either and included at all. It's so sad. It's very, very sad.
Yeah, but North Dakota is making advances in that, and that's having a health care directive directory where my office can assist our clients to upload copies of their healthcare directive forms, their living will, and HIPAA release. So we are able to upload those so that any medical provider is able to search for that information and download it and have it. And I feel like North Dakota and all of our various medical providers and institutions with electronic record sharing I feel like we're making a lot of advances so that will be something that will be available. But I always try to have my clients share. I tell them, this is an extra copy for you to bring to your next doctor's appointment. Make sure you get a copy of that on your file. And sometimes they ask that we provide it to their medical provider, but that puts a lot of liability on us to do that. And sometimes, we're not the best entity to be providing that to a clinic or a hospital. So it is the patient's responsibility to communicate back and forth between their lawyers and their medical providers.
And I would love to see my dream world would be to be able to do it all, if we could do it virtually and have the virtual remote on there for notarization and all of this. And then we can pull in the other healthcare directive people and all of that too. So
yes. So this is just going through some more scenarios that come up. So that was just an issue with the first meeting with the lawyer. There are so many other issues that can come up in the future, meaning that maybe Ralph's health declines and he can no longer drive. How is that managed? what happens if Judy's health declines and she is no longer, I see so many times where the spouse is the primary caregiver, and that is really hard on them physically. And so just some of those concerns, and then any like challenging decisions when Ralph, like let's say Ralph is in an emergency situation and now his children need to step up and make some decisions for him, but they have no idea, they have nothing to refer to as to what his wishes are. And then Ralph had expressed that he absolutely did not want to go into a nursing facility. Sometimes that's the only option unless Ralph is able to, there's a family caregiver or even depending on what his spouse's health is, it might not be feasible for him to continue to live in his own home any longer. And then I would just mention again that once somebody has passed away, then these medical power of attorney and living will, they're no longer effective. But the HIPAA release generally will continue to be effective after death. We have been drafting them to say that anywhere from 2 years to 99 years after the death of an individual, their nominated agent should still have the access to their patient records.
Yeah, we're kind of running out of time here.
Yeah.
So we'll let people kind of read the rest of the slides because we had so many things, you know, these were the big things that are lessons learned. Do you want to express them or you want me to? It's kind of up to you.
I feel like we kind of covered these, but yeah, that you really want to share copies of your legal documents with your health professionals and also with your nominated agents. And to provide to either explain or have in writing or some other way of communicating what your wishes are with your agents and medical providers and making sure that that is reflected in the document. And then knowing when a post is necessary, if you want to kind of touch on that.
Yeah, and that's a, you know, that should actually come from the medical provider. We may include, you know, that people have the brochure about what it is to give them some information, but we hope that the medical providers will be the ones that will be implementing and suggesting that when it comes up from it too.
Also, I guess, understanding what the difference is between a do not resuscitate or what a limited treatment would be. I'll let you kind of touch on some of these, but I will just, the last point there being that advanced care planning is a process. I always tell our clients that we need to revisit their documents every year to every 3 years at the maximum, so that they remember and understand who their appointed agent is and what their decisions were.
So our conclusions is, you know, we talked about the POLST forms and where it fits in, and that it is, when it's used appropriately, can really be functional to trust, you know, protect that person just like the trust does. And that we can ensure that people have these things when we have an advanced directive and they can complement one another, that they're consistent despite changing circumstances, that we stay on top of that. And so that the POLST form is not going to usurp the advanced directive. It works as a co-pilot. I love one of my chaplains said they're like kissing cousins. You know, they aid along the trajectory of, you know, a person's illness at any given time. And that we do need to know both the legal and the ethical sides of things as we move forward with this.